Hi, I'm attorney Gregory Dell, and I'm here with attorney Cesar Gavidia, and we're going to talk about ERISA disability lawsuits and ERISA long-term disability denials. And Cesar, we've handled thousands of long-term disability lawsuits against every major disability insurance company. But in this video, I want to talk about what people should expect when working with our law firm, what the process is like, what the timeframes are going to be, what we're up against and these kinds of things, because it's one of the most unique types of lawsuits of any area of law out there. So let's get into first, if a person they've received their denial letter, what's the first thing you're going to need from them and why in order to get the process started to get them to get their benefits paid?
We're going to want to see the denial letter they received and their policy. Those are the first items we're going to want to review and consider before we start really rolling down the path of drafting the complaint and filing the lawsuit. And once we've received that from them, what do we want from the insurance company? We're going to want the claim file. We're going to want that full administrative file that they have that sometimes some lawyers, in my opinion, it's not a very good decision to wait till after filing a lawsuit to get the file from opposing counsel, because it could take months before you get that file. So what I like to do is get the file from the insurance company directly before we file the lawsuit. And actually having that really lets us frame the complaint, frame that legal document that's really needs to be near perfect in order to get the lawsuit going and bring the insurance company to basically have to answer for their conduct and the reasons they've denied the claim.
So a lot of people are watching this video, they just got their denial letter. They may have gotten the claim file, although unlikely because a lot of times people don't ask for it after they've been denied. How quickly can you take action and how long is this process going to take to get the lawsuit filed and then possibly to get to a resolution?
Well, ERISA lawsuits, unlike breach of contract lawsuits against an independent or individual disability insurance company who's underwritten a policy directly to the insured, they're vastly different the way that you handle each of those types of cases. In the case where you have an individual disability insurance company and policy, there may be some time you need to build that case up before you file a lawsuit. With an ERISA lawsuit, an ERISA claim, where you have these employee benefits at issue, you already have that administrative file created before you file the lawsuit. So there isn't you've already done the building up through the administrative appeal process. You're not going to have any extra time necessarily before you have to draft the complaint and file the lawsuit to build that case up. So we could get jumping on it immediately. As soon as I get that file back from the insurance company and we've gone through that, we start with that process of drafting the complaint and filing the lawsuit, and we hit the ground running with all of that.
Yeah, because I know when claimants, look, if they're at the point of a lawsuit, they've been denied for several months. Usually it's a minimum of 6 months they've gone without benefits because they had 180 days to do their appeal. Disability company never makes a decision in 30 days. They usually take 60 to 90. So they're usually 9 months out, and they're already at the point where they're like, how much longer is this going to take before I start to see money? So I know in our practice that we want to get the fundamental information we need, which is the denial letter, the policy, and hopefully the claim file. Although we can file without the claim file, it's our preference to get the claim file. So like you said, we can be a little more specific in our complaint and nail down any other issues that may come up. One of the great things about this ERISA law, although there's not a lot of great things about it, is the fact that we can basically file these lawsuits in any federal court throughout the country and have the opportunity to represent claimants nationwide. So claimants don't necessarily have to worry about, oh, I got to find a lawyer in this town or this state or wherever they live, whereas we've been able to help claimants in all 50 states, which is why we have filed thousands of these lawsuits. So that's a big advantage. Claimant will never have to leave home, which is a wonderful thing. And how much work is there going to be on behalf of the claimant in an ERISA disability lawsuit? What's their time commitment going to be?
For the claimant, really not much. I guess the way we see it as litigators, a little bit of the disadvantage we have with these ERISA cases or ERISA trials, if you have a trial, is you can't bring the insured up to testify on the stand. The federal judge is never going to hear their voice necessarily. They're never going to be direct examined by us or cross-examined by the attorney for the insurance company. I guess it could be a little bit of a double-edged sword, because you've always talked about how important the medical records are, the foundation is, because you are as disabled as you appear in that administrative file and in those medical records. But in terms of a commitment from them, there's going to be certain things we probably will be engaging in, like mediation, which is when the court orders you to sit down with the insurance company and their attorneys to sit down to try to resolve the case, to try to settle it before they the court ultimately has to make a decision that one side or the other isn't going to be happy with.
So people are thinking, how am I going to be able to afford a lawyer for this? It's a lot of time on behalf of the lawyer, basically almost no time involved for the claimant, because it's our responsibility to handle every single thing. How do we charge for these types of cases?
We charge strictly on contingency, and the beauty of that necessarily is that we're taking on all the risk. We're the ones who, we are not being paid until we actually obtain a successful result for the insured, whether that's through a settlement or whether that's through a favorable judgment. Okay, so if either of those things don't occur, the client doesn't owe us any legal fees or expenses or costs that we've put forth. And that's part of working on contingency. And in terms of working any other way, it's really complicated and difficult, because these cases could take hundreds and hundreds of hours. And for someone who may already be very strapped in terms of their income, it's going to be hard to afford to finance a complex ERISA litigation case through a trial, through litigation, and through a potential trial or motions for summary judgment.
And so because of the high risk associated with these and the fact that we never charge any fees or costs unless we win, we limit our caseload so that we can put the amount of attention that's required into the particular file. The other thing about that, and the fact that we've been doing this for so many years and have handled so many, is that in most of these cases, if we win following a judgment from a federal judge, there will be an attorney fee award. Because if you're considered the prevailing party and if you win, then you're going to get an attorney fee award. And due to the fact that we've done so many of these, our attorney fee rate that we would get awarded by the court is going to be higher than almost any other law firm out there. And with that, that becomes a credit back to a claimant that it will reduce the amount of attorney's fees and help them to become more level and basically made whole through an attorney fee award. So that's a great thing if you reach that level. But Caesar, we talk about the possibility of going through a court case which could take 18 months or 2 years or 3 years with an appeal. But the reality is that a lot of the cases are resolved a lot sooner than that through a process called mediation. And can you talk about that and how these cases usually resolve and why they resolve through a settlement?
Well, mediation is a form of what's called alternative dispute resolution. It's when, and it doesn't always have to be the court ordering it, but it's very common, very common for a court to order it, because these federal courts and federal judges are backlogged, okay? And if they would like to see parties who have a dispute against each other just, reach some sort of, common ground and resolve the case. But sometimes parties, and we happen to having spent many years handling these disability insurance cases, we see many of the same attorneys on the other side, we see many of the same people from the insurance companies on the other side, and we sit down and we have this process of mediation where we try to resolve our differences. It doesn't always happen, but it happens often, and the advantage of it is the fact that the risk is removed. If we reach a resolution that's fair and reasonable and satisfactory to the client. And it's always their decision whether they're going to agree to settle their case or not. The decision's not ours. What we do and what we're required to do for them is to advise them and to counsel them through that process.
But what does a settlement mean? Does that mean they're going to say, we'll put you back on claim? How do these claims usually resolve?
They usually resolve in what's called kind of a lump sum global settlement. In other words, they resolve, the case settles, and you resolve the dispute over the back benefits that you may have with the insurance company, and potentially even the future benefits, future stream of benefits that you may have for the life of the policy, however long that may be, to age 65, possibly 67, maybe a lifetime in some cases. But there's other ways. It's not always strictly one way, because we've had creative types of settlements that were beneficial to our clients And it's always about what's best for the client, whether that's through a lump sum settlement or through some other sort of resolution. We're focused on what basically their needs are and what they need.
And I wanted clients who are considering moving forward. A lot of people get scared away and they're like, I don't want to battle this billion-dollar company. But 99.9% of the claims that we've handled for claimants where we have filed a lawsuit have resulted in them getting some form of benefits, whether it's a lump sum settlement or it's being placed back on claims. So the fact that we review claims, take these on contingency, if we're willing to accept the claim, then basically there's a 99% chance they're going to end up with some kind of money. Is it the full benefits that they would have gotten through a settlement? Absolutely not. If they get back on claim, will it potentially be the full benefits? Again, if you win these cases, what a lot of people don't understand is you get your back benefits and you get the opportunity to go back on claim. There's never a guarantee that they have to continue to pay you until the policy ends. And so that's the other unique thing about this. This isn't like I'm owed $500,000 over my life, I win the case, you're going to pay me. No, you can win the case, they can pay you $100,000, $200,000 they owe you in the past, you have another 10 years of benefits, and they can try to deny you again after. And that's the reason why a lot of people just want to get rid of the disability insurance company and say, I want some finality, I want some guarantee. I don't know where my next money is coming from, but I'm interested in this type of lump sum settlement. So certainly when someone calls us to discuss the claim, we'll let them know right away an expectation as to what we think the value of their claim is, what the chances are of winning. There's no fluff when they call any of our lawyers. This is what it's going to be, this is what we think we can get you. If you're satisfied with that, if we think, if that's realistic and you're okay with that approach, then we'd love to help you. If you have another vision and we don't think we can win the case, we're going to tell you straight up and we won't be able to accept the case. So we really want to have that candid conversation with the claimant. What I want to digress into now is for people to understand the challenges of these ERISA disability lawsuits, the standard of review, the burden of proof. Why is it very often so difficult where the insurance company more often than not has the advantage over the claimant, and a claimant truly doesn't get their day in court with ERISA disability claims?
Yeah, unfortunately with ERISA cases, and this is true, across the country, these insurance companies have worked in what's called these discretionary clauses into their policies. Many states have found this so wrong that they've banned these clauses.
About 15 or 17
right,
of them.
but not a majority of them.
Right.
So you know that there is still a vast majority of our states that recognize these clauses and basically give the insurance company the benefit of the doubt at the federal court level when you get to that lawsuit that their decision was correct. So you've really got a high burden and a mountain to climb to get over that. And unfortunately, it doesn't lead to very good statistical results when you look at just, the broad range of these ERISA disability claims and cases. The way that basically we handle that is you got to attack that standard review, and we've done it many times. There's been cases where you yourself have looked through these disability policies and we've argued in court that the standard review is invalid that they have. It's not part of the policy. We've done these things. That's how important it is to try to attack that, because the advantage of the insurance company is immense.
And so when we talk about the standard of review, can you explain briefly in simple terms what arbitrary and capricious review means and how a judge has to look at this claim, as opposed to someone's expectations are the judge is going to look at it, and if he thinks I'm disabled, I'll get paid. If he doesn't, I won't. But why?
Right.
How does it really work?
Well, basically how it works in the real world in terms of the real courtroom legal analysis that the judge goes through is they basically have to go through a step of finding that the claimant is disabled. Okay? They review the records, they review everything, and they say they're disabled. By what I'm looking at here, by the totality of these documents and the information in them and the opinions of their doctors, they're disabled. But now the judge has to go to a second step to determine whether the insurance company acted in this unreasonable manner, okay, this arbitrary and capricious manner.
So just because the judge finds they're disabled, it's not over, they win?
Yeah,
okay.
It's not over. And if the judge looks at the way the insurance company handled the review of the claim, let's say they sent it to 3 or 4 different physicians, okay, of their choosing, of course, but they've sent it to, a neurologist, orthopedist, occupational medicine doctor, and they had an internal medicine doctor look at it, and all of these doctors are saying the same thing, or perhaps, your doctor had said something or caused, some sort of event to occur where the insurance company now has said, well, your doctor's belief is this, and that belief is wrong, and your doctor tried to turn that around and say, oh, well, I didn't mean it that way. The judge finding that you're disabled could still say, well, the insurance company reasonably relied on these 4 doctors that they chose, or the insurance company reasonably relied on this mistake that your doctor made. And even when your doctor tried to walk it back, their decision wasn't unreasonable. Okay, they had it then reviewed again, and they came to this decision. So I'm sorry, you're disabled. I understand that, but I didn't find the insurance company acted in an arbitrary and capricious manner, so I can't find in your favor.
And so that's incredibly unusual, because the judge basically saying, if the insurance company acted reasonable in their review, even though I don't agree with their conclusion, then I can't reverse the decision.
Right.
And because of that, more claims are won by insurance companies than are won by claimants. And that's a difficult burden and highly unusual, because most people think they go to court, and court is fairness and justice and level playing field. But if there's an arbitrary and capricious standard of review or discretionary clause in your policy, then you're gonna already be at a disadvantage. And we really want claimants to understand that, because when money gets thrown out on the table to possibly settle the claim, you have to understand the risk that are there. And these cases can be won. They're won all the time. Just because the company did a review of your file or sent you to an IME doctor or hired 10 doctors. We have cases where they hired 10 doctors. It still doesn't mean their review was reasonable, because the doctors every single one of them could have not been reviewing the correct information, didn't consider the definition of disability, the occupational definition. There's so many factors and arguments, and that's why it's so important to have an experienced lawyer who's handled these ERISA cases, because hundreds of these come out every year. When I say come out, that means decisions from federal judges.
And you never know what that federal judge is going to be really tuned into.
Right.
They may be hanging on one specific thing. We had a case where the judge, they had several doctors on their side, but the judge hung on to the unfairness and the reliance that the insurance company had on a particular piece of surveillance video. Right? And they just focused in on that, and they really slammed the insurance company for that particular reason.
And another big thing that happens all the time is a claimant's been on claim for 2, 3, 4, 5, 10 years. Now the insurance company says, we're not paying you anymore. They have another doctor look at the file. That's their basis for denying them. Doctor just does a paper review. And the courts a lot of times are like, what changed? Besides the fact that you just hired this doctor who reviewed the records, never even saw the claimant, never even spoke to the claimant, how do you now reasonably rely on that particular doctor and ignore the 3, 4 other doctors of the claimant as a basis to review the claim? So yes, there is this uphill battle for a claimant, but at the end of the day, with the judge, they say the nature of the judicial process, meaning the judge brings his or her personal experiences to the table and is going to look at it as a reasonable person and say, if that was me, how would I look at this? How would I feel about the reasonableness of the insurance company's experts and the claimant's experts? And that's what has to be articulated, and you really have to be a masterful writer as an attorney in terms of how you present the appeal and be able to intertwine your argument with the supporting case law that's out there. And that's the art of doing this, and that's how we've been able to help thousands of people to be successful in the disability lawsuit stage when they've been denied. So, we scratched the surface here. We would love to offer you as a claimant a free initial consultation. So that involves sending us a copy of your denial letter, a copy of your policy, whether it's myself, Caesar, or any of our other disability lawyers. We'll immediately review that denial letter and policy. We'll get on the phone with you. We'll let you know if we think we can assist you, the chances of success, what we think the value is of your claim, what we think the time frame is going to be, and really answer all of your questions so that you feel comfortable about what the process is moving forward, what we're going to charge you to handle this claim moving forward, which we mentioned earlier is always a contingency fee basis, which means no fee or cost unless we win, and really just walk through all of your questions. So no matter where you live in the country, we look forward to the opportunity to discuss your claim and help you however we can.